Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. My name is Mary Nardella and I will be presiding today. We have with us the Honorable Judge James Edwards from our court, as well as we're lucky to have the Honorable Judge Louis Calderon from the 9th Judicial Circuit. Today we will be hearing the case of Robert M. Day versus State of Florida Department of Management Services Division of Retirement, which is case number 20-765. We are being recorded. Each side is allotted 20 minutes. Mr. Levy, if you don't tell us otherwise, we're going to reserve 5 minutes of rebuttal time. And with that, you may proceed.
Thank you, Your Honor. My name is Lauren Levy, and I represent Robert M. Day, who was the former Osceola County property appraiser, and I would like to reserve the 5 minutes for rebuttal, if I may, before I proceed. Your Honor, this is a case involving whether Mr. Day has forfeited his retirement benefits through his 2 felony convictions that were affirmed on appeal, or restated whether the Division of Retirement correctly forfeited those retirement benefits. It's our position that under the particularly unique facts of Mr. Day's case, that the division has misapplied the law and committed error, and that Mr. Day's should be found entitled to his retirement benefits. As you research this area of the law, there's a great many cases involving employees and or public officers challenging the forfeiture of their retirement benefits. Those cases tend to have a couple things in common. One, they tend to involve employees or public officials that have a long-term basis in the retirement system. Many have entered what's known as the DROP program, and the crimes were committed either during the DROP program or immediately prior to it. And there's a great many arguments that are brought forth where the public official is attempting to avoid the retirement of those benefits. And it's understandable. If you have 30 plus years in the state of Florida retirement system, those benefits are very valuable to you as a person. They're also valuable to your family members as they can also renew to their benefit. This case has 2 very unique factual aspects to it that requires, it involves some intellectual curiosity for me as I was asked to help Mr. Day. The first very unique fact was that when the division sent out its initial forfeiture notice in 2006, that forfeiture notice was never delivered to Mr. Day. He never received it, and the division closed out their file once the 21 days had passed to challenge that notice. All of that is in the record. Actually, that notice is sent out, appears as a matter of course, basically immediately upon conviction, even if a direct appeal of that conviction is pending. Many years later, Mr. Day went to the Division of Retirement and discovered that the letter had been sent, and his window of opportunity to challenge that decision had long since expired. We filed a request with the division to reissue that decision, since its own records indicated that the certified mail piece had been returned unclaimed or undeliverable, or unreceived, may be the better word. Yes, Your Honor.
If you don't mind, can I ask you about one of the first arguments that you make in your brief, which is that Mr. Day is not a public officer? And your argument seems to hinge on the fact that one cannot be both a public officer and an independent constitutional officer. Do I have that right?
Well, you have the argument correct, Your Honor, but I do believe that what the Division of Retirement had determined was that Mr. Day, as the property appraiser, was the employee of the county, and therefore would fall under Section E2 and forfeiture would be appropriate under that. I've never argued that Mr. Day was not a public official. He certainly is a public official, but he's not an employee of the county. Your Honor, he is an independent constitutional officer.
Didn't the
Mr.
hearing
Day-
officer, excuse me, Mr. Levy, didn't the hearing officer and the department also determine that he had committed a specified offense under subsection 6 of committing any felony?
Yes, sir, that's correct. So it's a
Right,
two-part test, if you would.
Well, they're in the disjunctive, aren't they? It's or, right?
I'm sorry, I didn't mean, yes, you're correct. Absolutely.
I understand, but so whether or not he was a public employee and stole from his employer, I understand the argument, and I think it's maybe a very good argument. But since he was also found to have forfeited his money, his retirement benefits rather, under that subsection 6, why does it really matter whether he was an employee and stole from his employer?
Well, I think you're correct. I think
Okay.
You're absolutely correct. This case really boils down to the felony aspect and the fact that the felony statute was subsequently amended so that Mr. Day's offenses, as of the time that the division is looking at whether his retirement benefits should be forfeited, at that point in time, although Mr. Day was convicted of felonies, and that we acknowledge that, but at that point in time, the dollar amounts would no longer constitute a felony. They would be a
Mr. Levy,
misdemeanor.
you do a very nice job of explaining the history of the savings clause and the new enacting legislation. But my question is simply, when you read subsection 6, which Judge Edwards pointed out, it just says the committing of any felony. And it strikes me that if Mr. Day were to fill out an employment form and he was asked if he ever committed a felony, he'd be checking that box. So the plain reading of the statute seems to cut against the long and artful analysis that you did. And I was hoping that you could address that.
Sure, Your Honor. And I think the best way to look at that is all of the cases that view forfeiture of retirement not as additional punishment, but rather as a breach of contract. That all of the appellate court decisions have been fairly uniform in that this is not additional punishment. We're not looking at the excessive fines clause and things like that. We're looking at it as a breach of contract issue. And so the way I would look at it is, let's just put it in the commercial context. We have a contract. At one point in time, the contract was breached. But by the time you're in court seeking your damages on the breach, there's no longer a breach. Arguably, you may be entitled to whatever damages may have incurred between the initial breach and the cure, if you would. But at the time that the division is determining, has the contract been breached? Should there be a forfeiture? The offense would no longer qualify as a felony. And so we start there, and then we go to the well-established case law that we are required to view these statutes or interpret them in a light most favorable to Mr. Day or against forfeiture. Then I would suggest that in this peculiar type of factual event, that the appropriate disposition would have been to authorize Mr. Day's retirement benefits. And if you want to be fairly detailed about it, and I noticed that we weren't in the brief, from the point in time of October 1, 2019, in other words, when the breach of the contract was arguably cured and the threshold amount for the felony was changed.
Mr. Levy, I understand what the case law says, and you were quite forthright in setting forth that the courts consider this not to be a punishment for conviction of a crime, which to me is a little logically hard to follow, but that's the law here in the state. It seems to me that they forfeit your retirement benefits because you have been convicted of a crime, which seems to me, and I think at least a couple of courts acknowledge that certainly sounds like a punishment for conviction of a crime, but it's not in Florida. That's the law. And you're relying on 775.022, correct? For the application of the amended statute setting the higher threshold for felony theft, correct?
I don't think we're solely relying on that, Your Honor. I think that was a discussion of what do you do with criminal statutes once they've been changed. And this court has looked at.
Are you relying on it at all? I'm sorry, are you relying on 775-022 at all?
Yes, sir.
Okay, well,
Yes, sir.
That statute seems to apply only if it's a penalty, forfeiture, or punishment for violation of a criminal statute. And the law in Florida is, logical or not, that this type of forfeiture is not a penalty, forfeiture, punishment, or fine, anything for violation of a criminal statute. So I don't understand how this really helps your client's position.
Well, I don't disagree with anything you said except the very last sentence that it doesn't help my client's position. It certainly, I believe, indirectly supports the concept that when we're looking at what do we do when a criminal statute has been changed, and what do we do when we look at just call it adverse consequences stemming from that conviction. We do have some direction that we're to look at.
Logically, I understand where you're going. I understand the analogy you're trying to make. But anytime we're construing a statute, don't we have to really read the statute, rely on the words of the statute? And, you know, perhaps on occasion you can make an analogy, but typically that's not how we analyze statutes and whether or not they apply.
I would agree. I would agree, Your Honor. When you look at this, when you look at 775-022, it does not directly apply to Mr. Day's case.
Okay.
Just like the case law dealing with all the licensure decisions, Your Honor, where the administrative agency is to consider the law in effect as of the time the administrative agency is making its decision. Is Mr. Day's issue a licensure decision? No, sir. But is it to me, it's similar in that, you know, a licensure decision certainly implicates your, you know, right to make a living, your ability as a business to operate in a certain area. That we're going to take into account how the legislature may have changed the law over time. And here for Mr. Day, we have, do you have to retire? Do you have to forfeit your retirement benefits when, as of the time we're now having to make the decision, the offense would no longer qualify as a felony? Do we give administrative acknowledgement to that fact? Or do we just ignore that and say the only thing that matters is the felony criminal convictions in the first instance? And I think, Your Honor, Judge Edwards, that then ties it back to this is some type of punishment arising from the original criminal conviction, when the courts keep telling us all the time that no, this is really a contractual a breach of contract issue that stems from these convictions. And so at this point in time, when the division finally got around to entertaining Mr. Day's appeal of his forfeiture decision, at that point in time, there was no longer a breach of the contract.
In order to rule in your favor on that issue, we would basically have to in some way either distinguish or perhaps ignore the existing law in Florida that it's not a punishment or a fine or a forfeiture for violation of a conviction of a criminal statute. How can we do that in this case?
No, I wouldn't be asking you to ignore that line of authority. In fact, I'm trying to distinguish the issue before you from that line of authority. This, if you look at it at a very basic level, this is a contractual issue. That's what the courts have said. Forfeiture is a contractual issue. And so what do we do with a contract where we have an initial breach that is subsequently, and I'll use the word cured, and that's an inartful word, but it is no longer a breach as of the point in time when the judge is deciding what damages should flow from the breach. If this was in trial court, you could get damages for the interim period between the initial breach and whenever it was cured. But from the point in time it's cured, there's no longer any breach. There would no longer be any damages stemming from that action, I
Right.
think is the best analysis.
I don't mean to cut you off, but I understand your argument completely, but I don't see how we can say, well, this is a contractual action and then look at a statute that only applies to punishment imposed for criminal convictions. I understand the analogy argument, but I'm just having a trouble getting from point A to point B, quite frankly, on that. And you can ponder it during your before you come back for your rebuttal, if you like. But that's really a problem I'm having. So.
Okay, and I'll be sure and try to address that on rebuttal, if I may. And I guess before I step down, I do just want to emphasize we have two very unique situations here. We have a 13-year time period between the convictions and when Mr. Day actually receives his notice of forfeiture. And we have the legislature changing the felony theft threshold. And then also the third thing in there, which is it just from reading all of the cases in this area, it seems that the number of individuals whose felony would fall between the $300 and $750 threshold. In other words, where that would make a difference is it just never happens. All of these thefts or embezzlements or whatever, however you want to view it, seem to be of far more significant amounts than the $728 for moving his furniture and the $667 for having his employees help him put a blue tarp on his roof. I'll reserve the remainder of my time for rebuttal. Thank you.
Ms. Davis, whenever you're ready.
Thank you. Good morning, and may it please the court. Mr. Day, as the former property appraiser of Osceola County, was convicted of 2 felony counts of theft. And the underlying actions of Mr. Day, we believe, were sufficient to warrant forfeiture of his state retirement benefits under the 2 separate provisions of the Florida statutes that apply. Chapter 112.3173 provides that a public official convicted of a specified offense forfeits his state retirement. And so the first subsection that the department found it was appropriate to forfeit Mr. Day's benefits under was the theft by a public officer or employee from his or her employer. And then the second provision was the commission of a felony, which is sometimes referred to in the case law as the catch-all provision. And the department maintains that forfeiture under both of those subsections was appropriate, but would note that this court would only have to find that forfeiture was appropriate under one or the other for the forfeiture to be ultimately upheld. So the first, theft by a public officer from his employer, that can be a misdemeanor or a felony theft. And I believe Mr. Day's only argument is that he does not believe that Osceola County was his employer. And so we would note at the outset that a public officer for this particular forfeiture provision to have meaning must have an employer. And we think that when you look at the facts and circumstances and the relevant authority as a whole on this point, that Osceola County was in fact his employer, at least for purposes of this particular and specific subsection of the statute. So Mr. Day was an elected official. He was elected by the county electorate to perform day-to-day duties at the county level, assessing properties. We would note that the Florida Constitution identifies him as a county officer. And we would also note that the Florida Supreme Court case of Beard, we think is particularly instructive. It's cited in our brief, and it discusses how a sheriff, who is also a county officer, is an integral part of the county.
But
Yes,
Ms. Davis, none of what you cited so far turns the property appraiser into an employee of the county specifically and literally, does it? I mean, nowhere does it say that. Correct?
Not specifically. We have
Okay,
not located.
let me ask you this question. in an employer-employee relationship, the employer typically has the right to tell the employee what to do, when to do it, where to do it, and how to do it. And also, typically, the employer has the ability to terminate or fire the employee, correct?
Correct.
And here, the county has none of those powers over the property appraiser, does it?
That is absolutely, that's correct, Your Honor, but we would note that it's got to be somebody or someone for this provision.
On to Judge
Yeah.
Edwards' question, what control at all does the county have, or direction does the county give to the property appraiser, guidelines that the county sets out that he must perform?
So the record doesn't reflect any, and there are certainly some constraints to this relationship. This is not your typical employee-employer relationship, but he didn't go out and apply for a job. He wasn't hired. He can't be terminated. Those are all correct. But at the end of the day, he's got to have an employer. And so we don't think there's any support for the fact that it would be the state or anybody else. So when you look at the facts as a whole, he was elected by the county electorate for Osceola County. And upon his election, he became effectively an employee of Osceola County, at least for this particular provision of the retirement forfeiture statute to have meaning. A public official has to have an employee that he can commit a theft from. And so looking at the case law that's out there, he does have ties to the county. The Supreme Court case of Beard discusses the fact that county officials are an integral.
But Ms. Davis, Beard is finding that the sheriff was part of the county for sovereign immunity waiver purposes, not for this statute, correct?
That's correct.
So
Yes.
how does that help us out here? It doesn't say the sheriff was an employee of the county. It says he's part of the county. Nobody's arguing here that the property appraiser is not a county officer. I mean, that's clear under the Constitution. And the question is the employment relation. And again, if you're looking at a sheriff, a county has very little control in it in terms of what you would expect from employer-employee relationship to the sheriff. So I'm not sure how that helps. Under the catch-all, appellant has agreed that the hearing officer and department found that applied. And are you trying to stay away from that one for fear of whether it's still a felony or not?
No, I just wanted to point out that we thought the department believes it has good arguments for why it found that ultimately that for purposes of this forfeiture, the employer had to be somebody. And we think the record and the case law supports that the most appropriate employer is Osceola County. But if you'd like me to address the felony argument, I can do that next, Your Honor. So the statute requires that a public official be convicted of a specified offense. And in this case, Mr. Day absolutely was convicted of a specified offense. There's no evidence that those convictions are not on his record anymore. We believe that they are. And it was pointed out, I believe a few moments ago, that if he had to fill out an employment application, he likely would have to check that he is still, in fact, a felon. So we believe that the case law that interprets the retirement forfeiture statutes provides very clear authority for the fact that the relevant time frame is the time frame at which the crime was committed. At the time Mr. Day committed these crimes, they constituted a felony. The jury found and convicted him of a felony. That was appealed up through this court, and the court affirmed those convictions. So those felony convictions are final. And the department, I do not believe, is at liberty to disregard the plain language of the statute, which says if a public official is convicted of a specified offense, and he was convicted of these felony offenses that qualify under the catch-all provision, then forfeiture is appropriate. The fact that if he committed these same crimes today and the value amount was the same, that he couldn't be convicted of a felony today, that's just frankly not relevant. And we also would note that we believe that case law, in particular, the Bayfront case that's cited by opposing counsel related to the licensing statute changes, that case is not relevant to the determination before this court today. So the Bayfront case involved a pending licensing application for a trauma center. And during the course of that, while the application was still pending, there was a change that resulted in the fact that the application couldn't be approved and still comply with the law because the number of trauma centers allowed for the relevant area had been reduced. And so it makes sense in that circumstance that the licensing application shouldn't have been awarded by the relevant agency. Here, this case is completely different, and there are relevant cases, including the Busby case and the Shields case, that are directly on point that involve retirement forfeiture. And those cases stand for the proposition that the relevant time frame when determining forfeiture is the time the crime was committed.
I have a question about how you apply 775.022 subsection 2, where it defines the term criminal statute to mean a statute, whether substantive or procedural, dealing in any way with a crime or its punishment, defining a crime or a defense to a crime, or providing the punishment of a crime. And then you go on later down to the next subsection of what you do with that. I mean, the law is clear, and Mr. Levy, as I said in his brief, and here has been very forthright in saying that the courts don't treat this as punishment for a crime, again, logically or illogically, but the legislature did redefine the crime of theft. So it's a little hard for me there, where you're defining a crime and you're punishing or forfeiting based on a crime. If the crime has been redefined, where the forfeiture has not already been imposed, and forfeiture, not a fine, but a forfeiture has not already been imposed, you apply the statute as amended. And again, it's just a little troubling to me when you look at that language and then try to make that pair up with the holdings that it's not a punishment for violating a crime. Can you help me with that, please?
Well, so I think 775.002 clearly only applies to criminal statutes, and I think that's something that is agreed upon by the parties. That government pension plans are interpreted like contracts, and there's case law in this court, in the state, directly on point, that discusses the fact that an employee, to be entitled to a pension one day in the future, has got to comply with the terms of the contract, which includes the relevant statutory provisions.
Right, but actually, if you look at those cases, they say you're to apply the language of the contract, apply the language of the statute, and so forth. Yet they treat not committing a felony or another specified offense as a condition precedent. It's not. The employee doesn't have to prove that he or she didn't commit a felony or another specified crime to get the penalty, to get the pension or the retirement benefits. It's indeed a condition subsequent, where the state has to prove that the employee did commit a specified offense. So with all due respect to those opinions, they say to read the language of the contract and statute and then go about ignoring it, changing a condition subsequent into a condition precedent. But I understand that's the law, and to some extent we're stuck with it, but I'm not sure it's particularly well reasoned in some respects.
Right, and I think what really is relevant here, Your Honor, is that he was convicted. He was convicted of the felonies, and those convictions are still on his record. And I think maybe opposing counsel's argument about the fact that the breach of contract can be cured would be a little bit more on point if those convictions weren't still valid. and on his record. But the fact that they are,
Well, you stated that 775.022 applies to this case. But if you read, it affects any criminal statute. Now, it's defined in 775.022 that a criminal statute is a statute, whether substantive or procedural, dealing in any way with a crime or its punishment, and defining a crime or a defense to a crime, or providing the punishment of a crime. So wouldn't a broader reading of that statute include 112.3173 as dealing in any way? Because the central issue is whether or not Mr. Day committed what would constitute a felony.
so I think, Your Honor, the courts have not interpreted Chapter 1112 to be a punishment or to deal, or interpreted it anyway to be a criminal statute. They've aligned it more to a contract. Pension plans are contracts between employees and employers. So that's why the department believes that Chapter 775, since it interprets and applies only to criminal statutes, that it's just not applicable in this case. And that's been the position that the DCAs in this state have taken on that point. And so I would also like to point out, kind of along the same lines, that the Florida Contraband Act and the cases interpreting that, we likewise believe that those cases are not applicable. Again, for some of the same reasons. Clearly, they're read only to apply to criminal acts and civil forfeiture proceedings in circuit civil cases after a crime has been committed. And we don't believe that those cases have any sort of bearing on the outcome of this case here today. One of the seminal cases on government forfeitures and the contract terms is the Childers case. And so we think that case provides some authority for the fact that government pensions are a contract, and that in order to be eligible for your pension one day, public officials, they've got to abide by the terms of the contract, which include not committing a list of specified offenses. And I think Mr. Day, certainly at the time he committed the crime, he should have been on notice that his actions at that point in time constituted a felony. And so to apply some other sort, to retroactively apply some other standard would not, respectfully, we don't believe be appropriate. And so again, we think the forfeiture of Mr. Day's retirement benefits under both subsections was appropriate by the department and in accordance with the law. We do believe he committed a theft by a public official from his employer. We maintain that that was appropriate. And we also believe that the catch-all provision that is retirement forfeiture, that is retirement benefits, were also appropriately forfeited under that provision. And I would also direct the court to the Warsaw case, which is a case that we cited in our answer brief that we think is on point or provides some authority for the additional authority for this court. The facts, yes, are different. That case involved a sheriff who stole funds from a nonprofit and essentially tried to make an argument that the funds were not technically public funds, but the court did not go along with that argument. That argument was rejected by the third DCA. And we think the facts of this case are similar when considering the who Mr. Day was employed by. I mean, we maintain that Mr. Day was employed by the county. And I would note that Mr. Day is not denying that he committed theft. He's not taking the position that his felony convictions are not valid. He's exhausted his appeal options. And so for all of those reasons, I mean, we believe that the forfeiture was appropriate and should be upheld by this court.
Thank you, Ms. Davis.
Okay, thank you.
Mr. Levy?
Thank you, Your Honor. I did want to make one comment before we're trying to return to just Judge Edwards' questions. It is very hard to view the forfeiture of the retirement benefits as anything but significant punishment to Mr. Day. The entire criminal file is in the record on appeal. He ultimately was sentenced to 6 months, and he had restitution of the 728 plus 667 plus some court costs. His forfeiture of his retirement benefit for all these years since 2006 to now, and for the rest of his natural life, grossly exceeds that amount and is the most significant punishment that he has received as a result of these two events. It is very hard to disentangle those two. I understand that the cases say that this is just a contractual matter, and that this is not some kind of excessive fine or punishment issue, but certainly the forfeiture stands out as the greatest punishment that Mr. Day has incurred because of these two convictions. Judge Edwards, I would try to go back to your question and walk you through this thought process if I could. If this was a straight up criminal case, and we were now talking about a civil forfeiture proceeding that stems solely and directly from that criminal conviction, 775 clearly applies and would require the court entertaining the forfeiture action to apply the version of the statute in effect at the time of that decision. Regardless of when the criminal offense occurred, it would be at that point in time. It is hard to see how the division of retirement could have any rule or statute that would cause a greater penalty upon the person than what would happen if this was a straight civil forfeiture action. And when you look at some of the division of retirement appellate court decisions involving retirement issues, they do talk about these are forfeiture statutes. They are to be construed as other forfeiture statutes, such as a civil forfeiture statute, and they're to be construed in the light against forfeiture and in favor of the person retaining their property. So when you go through and you look at that, and then you also look at the fact that the division has argued that in the past, that, oh, this has to be a contractual issue that is disconnected from your criminal offense. This is not an additional punishment, so we can win or prevail on those cases, that they ought to be somewhat, in the vernacular, stuck with that argument at this point in time, that if this is just a contractual issue, there is no longer a breach at the point in time they decide whether to forfeit the benefits. And they should not be allowed to say, we're going to construe the statute in a manner more harshly than a civil forfeiture would be construed of a straight criminal proceeding. I do think the licensing cases are analogous in that regard. So we would certainly suggest, and I realize this is maybe a difficult opinion to write, but under the unique and probably unrepeatable facts of this case, that the division erred when it denied Mr. Day's retirement benefits. And thank you.
Counsel, thank you for your arguments today. It was well argued and well briefed. We will be adjourned.
Thank you.
Thank you.